Good afternoon and welcome to today's webinar. We're going to get started in about 1 minute, and we're so thankful that you have decided to join us today. We're going to be talking about when to hire an attorney. So if you have any questions, you can submit them one of two ways. You can either do it through the control panel, or you can do it by email at webinar@vannattorneys.com. I hope you all are having a great day, and we'll get started in about 1 minute. Thank you so much. Good afternoon and welcome to today's webinar. I'm James Vann with Vann Attorneys, and we're thankful that you have chosen to be a part of this webinar today. We really hope this will be helpful to you, and we're going to be talking about when should I hire an attorney to help with non-payment from your customer. So we're thankful again that this is a topic that one of our clients and one of our regular webinar attendees suggested. And I won't call out names because he's a client, so I don't tell who those are, but we're very, very grateful for that suggestion. And I'll be honest with you, we didn't think this would be a hot topic, but we have been really surprised by the number of people that have registered. So we're hoping this will help you, and hopefully you gain something out of it that will help you in your business. If you have questions, you may submit them one of two ways. You can do it through the control screen portal on your computer screen or your device, whatever that is, or you can do it by email at Vann Attorneys webinar@vannattorneys.com. And just for a little extra information, next webinar that we're hosting will be November 14th. It's hard to believe, y'all, that's the last one for this year. It's hard to believe that. It's just crazy. But that's the last one for the year. If you've got a topic that you want us to cover, please let us know. We'd be glad to put that in the mix and add that to the topic. So, all right, so let's talk about hiring an attorney. Some of the topics that we're talking about today is when to hire the attorney for non-payment, what services should you request, what options do you have, what's arbitration, mediation, how does that play into it, how do you handle that, what amount should be at issue that would justify hiring the attorney, and then what type of attorney should I look for. So those are sort of the topics that we'll look at. So most of you know this, but it's just sort of a nice reminder. What is a breach of the contract? When is that breached, right? So a minor breach is where one party fails to meet or perform minor terms of the contract terms, right? So it's a minor breach. It's not a material breach. It's not something that maybe it would qualify for a breach of the contract, like a suit, kind of lawsuit kind of thing. But it's more of a minor thing. Well, what if it's a material breach? That's when there is a substantial or material breach of the terms and conditions of the contract. So what's the difference? Say, for example, that payment is supposed to be made by your customer. I'm just trying to think of that. By company check, right? And instead they bring in a personal check, and it obviously clears. There's no problem with it. That might be a minor breach, right? They're making payment, or they're making the payment, say, on another company that they own. That company writes the check for it. So maybe that's the minor breach. That is, the payment's coming from a different company. Again, most people that wouldn't really be that big of a deal, right? Or they're supposed to make the payment at a particular branch or office of your business, and they go to a different one. Payment is accepted, payment goes through, there's no issue. That might be a minor breach, maybe. Not something that's probably worthy of a lawsuit. An anticipatory breach is when one party states or gives some scenario that they're not going to be able to fulfill the contract. For example, we've had anticipatory type breaches where there's a contract, say, companies to provide, say, 1,000 widgets or 1,000 products by the end of the month. And in conversations, when they go, guys, we're having a hard time getting materials. We can't make the widgets. I just don't think we're going to be able to do it. Or there's some other issue that comes up, and they say, we're way behind and we're not being able to do this. And let's say the widgets were expected by the end of the month, and that's a material issue of the contract. That's like a major factor because you're relying on that. That might be an anticipatory breach where you would send them a letter saying, hey, you need to tell me whether or not you're going to comply with this or not, because what you're telling me is that you can't comply with the contract terms, and therefore it's going to cost me more money. If you can't, then I need to do something else. So that's an anticipatory breach. But those are sort of the three types of breaches that are common in business contracts. So when do you hire an attorney for breach of the non-payment? Well, we get a lot of the questions like this. The customer's just not talking to you. That usually tells you something. There's one of our customers who I can think of, and I think this person may have signed on today, and their customer, they won't call you. They're not calling anybody in the industry like other suppliers, other companies. They're not talking to them at all. Something's going on. They have been paid by some of their customers that we've been able to verify, but the customer of our client, they're not talking to us. I've called multiple times. They're not talking. They won't respond. They're not responding to salespeople. That's generally a great indication something's going on with the customer. You need to follow up and probably file suit. Hire somebody else to help. What if the customer refuses to pay or ignores the request? Another good example. I've got a client who I talked to this week. He's been promised payment multiple times, right? And the person who's promising the payment comes up with different excuses as to why they haven't made the payment. And most of them, when you really look at it, like if you hear one or two here or there, you go, oh, that might be valid, right? I'll give them a little bit more time. But when you put them all together, you go, wow, they're just stringing them along. They're something else is going on. So I've got another client that comes to mind where he says that he's been talking to his customer, and the customer always says, "Oh man, I brought the check, I left it in my bag in my other car, or I left it in." He even said he left it in the computer. He closed it up in the computer to bring it, but he left his computer. I'm like, come on. After a while, you go, it's like so delinquent. The person who's telling you the story needs to just obviously bow down and go get the money and get the check and make the payment, but they don't. And then the other one is obviously if the customer files for bankruptcy protection, definitely hire somebody to help represent you in the bankruptcy. It may be nothing but monitoring the bankruptcy, trying to make sure they don't do something that they shouldn't be able to do. But if you don't object to it in bankruptcy court, then they may not be able to. Then you won't be able to do anything about it. So make sure they comply with those. So hopefully that helps a little bit, maybe. So what services should you request from your attorney or expect? And again, realize, and y'all know this, every case is different, right? It's you need to be able to hopefully talk with your attorney, meet with them, maybe talk with them by phone. And for a lot of you, we represent on an ongoing basis. We know each other. We know how your company runs and how you do the work, right? And for some of our clients who are one-time type clients or a client that we've never represented before, we obviously would like to meet them face-to-face if we can. That doesn't always happen, but I'd rather do it that way. But generally speaking, a demand letter is not uncommon. Have the attorney write a demand letter, send it certified mail, return receipt requested. That sort of opens up that door of, hey, and I'm representing so-and-so, and you owe X number of dollars, or you've done this, that's a breach of the contract. It sort of throws the first rock over the fence to try to get the attention of the other side. So that's certainly something that is not would not be uncommon, or would be probably pretty common to have. And then if it's a construction-related issue, having a claim of lien or a payment bond claim or payment bond demand, that's certainly something else that I think you can expect would be normal. A preservation letter. And preservation letter is a letter you send to the other side that says, you need to safeguard all your documents, all your electronic documents, your emails, text messages, any kind of documents you have that the company has, you need to maintain that, because a lawsuit is ensuing based off of this fact scenario, whatever it is. So we had a client not too long ago who was in business. It's a business that I think there were 3 owners in. One of the owners was not getting along with the other 2, and a fight was ensuing, and it was just pretty bitter, unfortunately, internal. So we sent a letter, the preservation letter, to the other side to say, hey, don't destroy anything, electronic or otherwise, paper. And quite frankly, if you do that, if you send the letter and you can prove later that the company said, you can prove that they discarded or did something to documents, either paper or electronic wise, that they tried to destroy that, they can get in some significant trouble with the court. It's a great letter to send where you think that, it's not every case, right? It's not every breach of contract type case or just a non-payment, but if there's real issues going on from a business perspective, then that's one of those things where it's probably very beneficial to send that type of letter. And again, it's like a big rock that you send over the fence, because it tells them, hey, we're getting ready to sue you. And they're supposed to safeguard it. What happens if you don't send a letter and they still just discard or delete confidential, or not confidential, but delete information that the company owns? If they do that, and if you can prove that they did that with the intention of getting rid of the evidence, that too is a big foul in the court's eyes, but not as much as if you had sent the preservation letter. So it's just a nice type of letter to send. Temporary restraining order is another document you can ask, and it may be applicable. It may not be in your case, but a TRO could cover. It's really a restraining order that basically says, I want to make sure everything stays like it is until the pending of this suit is over. Or it may be to do something or to stop doing something. And a lot of times it's like in a non-compete type setting or situation, or if a business is doing something that's harming alleges harming another business or another, maybe the trade or something, that might be applicable. But TRO is certainly possible. Certainly filing a complaint would be that part as well. And then something else I think sometimes we all sort of forget about or think about is legal advice and counsel. Thinking through the situation. If it's outside of just a simple non-payment, but even in, what's going on? Why are they not paying? Just legal advice and counsel. And then also to be able to negotiate with the other side. And many of you in business that I know that have logged in today, you're very good at negotiating. You're very good at listening. You're very good at perceiving what the other side is trying to do or trying to accomplish. You just got a good sense about that. Not that you don't, but hiring someone else to negotiate it for you sometimes can be helpful, be very helpful. One of the things I just mentioned about legal advice and counsel, we just recently had a case that thankfully settled in mediation, but we could not for the life of us figure out why this, what the issues were, because it was pretty straightforward. And I won't give you too many details because we haven't totally finalized all the deal, but in realistic terms, our client had provided a service. The other side thought that it was basically a guarantee for life, it seemed like. And the other side sued our client, and we countersued because they hadn't paid for everything they were supposed to pay. And it was really interesting. We got down to the mediation, and we realized that there was other driving factors, influences from the outside of the person who was representing the company, or the owner of the company. And even the lawyer, the other side's lawyer, was really sort of like trying not to have this thing settle. So anyway, it was just a great example of realizing that there's sometimes when you just have to keep pushing and keep asking and keep talking and listening to try to figure out what it is. So we got a question from one of you guys, or one of you, sorry, ladies or guys, said, could a first attempt be an email to the customer with a CC to the attorney to let the customer know that you're engaging with an attorney? Yeah, you could do that. What you want to make sure is that obviously if you say that's your attorney, you probably want to check with them, make sure it's not a conflict of interest with whoever your customer is before just call your lawyer. Hey, look, I've got a customer of such and such. I need to send a letter to. Can I copy you on that? Just to make sure there's not a conflict. But if that's the case, then yeah, you certainly could, and that generally indicates I need to step it up. So that's a great question. But yeah, you certainly could do that, and we've got some clients that do that, and that is helpful because again, it sort of shows to your customer, wow, they're about ready to pull that trigger on this, and I need to get it done. So that's a great question. So what options do you have? Well, if the party is a business other than a sole proprietor, like a corporation, LLC or LLP, then the business must hire an attorney to represent it in court. So again, if whoever you're dealing with on the other side, if they're a sole proprietor, then they can represent themselves in court. But if they're a corporation, a business, LLC, that kind of thing, they have to hire an attorney. They cannot represent themselves. Same thing for your business. If it's incorporated, you cannot represent yourself in court other than in very limited occasions. So just something else to note. So what options do you have? Well, of course, you got arbitration and mediation, state court and federal court. Sorry, I had to grab some water. So arbitration, and many of you know this, sometimes, I think back in the probably 70s and 80s and probably 90s, the arbitration provisions became pretty popular in some contracts to say if there's a dispute it's asked to go to arbitration. You really want to make sure that you look at that really carefully. And if you have that in your contract, you may really want it in there, and that's okay. I'm not saying it's a bad idea. People used to select arbitration because it was faster and less expensive. I will tell you today, I do not believe they're less expensive. They may be faster, but they're not less expensive. It was interesting. We had a case in arbitration. It was a fairly big case, and I always feel, and I hope this is not some indictment on my personality or how I handle cases, but I feel like almost to some extent they are too fast in arbitration because you're not able to actually get the facts, all the facts, and get it lined up in time. But I had another attorney and a arbitrator for a case, and say the same thing. They were like, you know what, these things, just the way the rules are, you don't have time to get what you normally would get to line up the facts. So you have to be really, really diligent when that clock starts ticking with arbitration. Again, I'm not knocking it. I'm just saying it's just a reality of the arbitration. And same thing, it's not less expensive today. I think it may be even more expensive than court, but you get it over with pretty quickly. So if you have an arbitration provision, that's something to take a note of. And then the other thing is, if you are, say you're contracting with your vendor or a service provider, and they have a arbitration provision in there, let's just say you're in North Carolina, but the service provider's home office, say, is in I don't know, Utah, right, or somewhere else. But you need to look at the arbitration provision. Where does it say that you have to have the arbitration, or if it says it? I know I read a lot of contracts for clients, and sometimes they'll say, you have to have the arbitration in Illinois, in such and such county. And we're like, wait a minute, we're not going to Illinois to arbitrate this. I've got one pending right now where we're trying to fight it in state court. There's an arbitration provision, and I can't remember what state it is, where we're like, we're not going to do it when we can't afford to do it, right? And we know if we go to arbitration in that venue, we're going to lose. So we've tried to say we're not doing it. Don't know if we're going to be able to hold on to that or not, but it's just something to think about. So what about mediation? Mediation is where you hire a third-party mediator who is non-biased, not interested in the case, and they actually help you try to settle the case. They don't tell you who's right and who's wrong, just an option. Some of the other options you have is state court. In North Carolina, small claims is up to $10,000, which is a lot of money, quite frankly, and you can do that in small claims. You do have to file the small claims in the county where your customer resides or has their primary business. You also have district court, which district superior and, of course, business court, all those you have to have an attorney, especially if you're incorporated. I should say you're going to have an attorney in those if you are incorporated, if you're a corporation. You can represent yourself as a DBA if you're a sole proprietor. Business court is something that got introduced in North Carolina, I can't remember, 10 years ago maybe. And there are certain issues that the business court handles. They don't handle all civil litigation. And again, it's a lot faster. There's some fees to it, and sometimes you can get a really good resolution pretty quickly. But again, it's not the run-of-the-mill breach of contract type case, so it's just certainly an option. And of course, federal court. Federal court, you can only get in there if there is jurisdictional or constitutional type questions. So if some of the parties are out of state, then of course you can get the federal court if you needed to or wanted to. We talked about arbitration and mediation a little bit. Some of the benefits of arbitration is it is certainly faster. I don't think it's any cheaper today or less expensive. I think that's a drawback, quite frankly. Some of the other benefits is it's outside the courthouse. You may not want your issues filed publicly. So arbitration would be a private setting typically. And so those are some benefits. The drawbacks probably against the cost. Could be the timing of it. And again, you're going by the rules of whatever arbitration rules you're using. And that may or may not help you. So it's something to think about. Mediation we talked about, probably not going to talk about that anymore. So what amount should be at issue to justify hiring an attorney? and I'll tell you, I really struggle with this idea about how to say this in writing, but also today. For example, we may get a call in from someone who we don't represent, and they have an issue that's, say, a $7,000 or $10,000 issue, and there's just really, in reality, no way we can help them. But if it's a client of ours, we're going to figure out a way to help them, right? Because it makes sense to do that from a relationship standpoint. And one that doesn't, if we had like a client that sent us, $25,000 cases, I don't know. I mean, we could figure out a way to do it, but we probably wouldn't look for that in the marketplace outside of a regular ongoing business relationship. It's just hard. I would probably say 10 grand and up is probably where most lawyers. I mean, some lawyers I know they don't take small cases, and that they consider that small. But that's a lot of money. So again, I think it really depends on the type of case. Is there an ongoing relationship? What is the jurisdiction and venue? Where's the case need to be heard? We just realized for us, we can help clients in a lot of different areas around the state. But when you get way out west, like, past Charlotte area, like way out past Charlotte, Asheville area, we just don't, it's harder for us to do that efficiently, especially depending on if it's smaller dollars. We just got hired to help in a civil litigation out west, but it's a huge case. And I think we can help. We're going to be able to help these people resolve their issues. But that's just, again, you got to think through those things a little bit, right? Some of the, we'll talk about the fee structure. There's an hourly fee, which most of y'all are aware of how that works. It could be a project-based fee. We've done this with some clients. You look at the litigation and you say, okay, let's break it up and divide it into sections based off of what we're doing next. And that's certainly a doable formula. That's not uncommon. Flat fee, you could do that. There's those options. A monthly retainer. I know we've had several clients ask us about doing a monthly retainer. We certainly don't oppose it, but there could be months when you or your business wouldn't spend that much money. But if you do a monthly retainer, you're sort of stuck into it. We've almost done that with several clients, but I tell them, I'm like, you need to really think about it, because once you enter into it, if you've got something that's hot and heavy, that makes sense. But when it cools down, that's sort of where it all sort of equals out or balances. And if you have nothing going on legally and you're writing a check for X number of dollars per month, that might create eventually a little bit of heartburn. Over the years, it probably balances out, but what I don't want to do is have unrealistic expectations from anybody, but at the same time be able to help people and hopefully be able to do that economically for us and for our clients. I hope that makes sense. Certainly a contingent fee, that is, your attorney gets paid if you have a recovery, that's an option. And then one that's called value billing, we actually I don't know that I've ever done a value billing case, but typically where that is at the end of the case, you and your attorney decide what the value of the services were. And there are times when, obviously, if you have a big win, everybody's happy, right? Or if you have a moderate win, could people be happy? You got to figure that out. And as I tell people, I don't ever want to fight over money. And I don't mean this to bring it back to personal. I just, I don't want to fight over money, frankly. And I'd rather have everybody have that understanding earlier, right? So that you don't have to worry about whatever that is. And I think most people would rather have that, I think. But anyway, those are some popular billing structures that they're going across the country now. What should you do, or what can you do to help or prepare? Obviously, the more organized you are with your documents, it's tremendously helpful to your attorney. Gather as many of those documents as you can ahead of time and just, group them together. Most people do it electronically today. You don't have to, but most people do. So again, gathering those documents ahead of time, organizing them, give all of the details to your attorney early, the good and the bad, right, and the ugly. So just say, hey, look, this is the good stuff. And a lot of times if we don't know the client or they haven't shared it with us, okay, what's the worst news, right? Tell me what I need to know so I know where we need to cover ourselves or figure out how the law is going to impact that fact or the facts impact the law. So you just need to know what that is, right? So those are some areas, and I think the more organized you are, the more you get the documents up front and have them organized, it helps people, right? It cuts down on the amount of time that the attorney has to go through those documents and organize them, or staff does, or whoever, and it eventually saves you money, hopefully, as well. But that just makes it easy. So what type of attorney should you look for? And I'll tell you, it was really tough not to decide to put a picture of me in there, but that's not the way we do it. So what type of attorney should you look for? Look for somebody who's got experience, in this case, civil litigation, right? Or whatever the issue is, you want to hire somebody that knows that practice area. Look for experience in that. What have they done? How long have they been doing it? In this case, civil litigation or business disputes, that's helpful. If you're looking for somebody to do estate work, you don't want to hire somebody that does real estate, right? Or vice versa. So look for experience in the area that you need it in. I'm going to tell y'all, the longer I do this, I've been doing it since '92, which is hard to believe. Look of the similarities between attorney and client. I started seeing this happening, and this is not always the case, but more times than not, the attorney and client have a lot of the same type values. They operate in a similar fashion. And sort of expectations are similar. And I hope that makes sense. Sometimes when I've had other cases, and I look at the other side, I'm like, I wonder why that person is representing that, why that party hired this attorney, or why that attorney accepted the case. And you realize that, there's a lot of similarities between that. And I even have found that with us. It's not always it's not 100%, ever. It's not 100%, but more times than not, there seems to be a connection between the attorney and client on values and principles, which is interesting. So, something to think about, right? Factors to consider, again, experience. Is the attorney well connected? Do they know people in the industry? Do the industry people know them? Are they well respected in the community? That kind of thing. Again, are the clients do they have other clients in your industry? Are they representing other people in your industry? Again, just an idea, just something to think about. That's always helpful. And I always think, do the people at the courthouse know who that lawyer is? That's helpful. You may not, that's hard for you to know, but are they present in the community with what they're doing? And again, that's just another piece of thing that can help. So I hope this has been helpful. If you have any questions, I hope you'll reach out to us and let us know. We'd love to help you with anything, with just a simple question, or you can email it or call us. If you have not connected with us online, we'd love for you to do that. We try to send out information electronically. I know a lot of you are on our mailing list, but also through the social connections here. Love to touch base with you. We hope this is helpful to you. If you have any questions, let us know. Hope you all have an awesome week. And our next webinar is on November 14th, and we look forward to talking with you soon. Thank you.